In the recent past, there's been quite a major increase in online pornography regulation, including criminalisation within the UK, and I'd like to explore a particular aspect of this. Let's see how the control works. To do so, I'll first give a quick overview of the legislation in play, present the perceived problem as I see it, look at what the legislation actually bans in practice, as well as the audience for this, and then I'd like to put that into context by asking whether it really matters, and then finally I'll conclude by suggesting where we can go from here. So first, we have regulations which take the form of licensing restrictions for online video on-demand programs. Those restrictions are contained within an amendment to the Communications Act 2003. Second, there's been introduction of criminal offences for possession of certain kinds of what's referred to as extreme pornographic materials. And those are seen in the Criminal Justice and Immigration Act 2008 as amended in 2015. So in the online context, this essentially means criminalisation for simply looking at certain types of pornography. And then finally, given how the vast majority of pornography traffic now takes place online, surveillance and investigatory powers are important, especially those that relate to ICTs. The Investigatory Powers Bill, which is just in its closing phases of passing through Parliament, it would seem, strengthens powers for accessing information contained online or in digital equipment. And it will be interesting to ponder, even just in passing, what effects that might have for online pornography. So what's the problem? Well, I would argue that increased regulation in this area is problematic for a number of reasons, but I would like to set out the argument that they disproportionately affect certain groups of individuals, as is displayed by the quotation on the screen. Now, these groups are broadly those who do not fit into what might be called standard heteronormative or male-dominated narratives that take precedence in portrayals of sexuality today. And that's a broad spectrum. It includes queer and female-focused sexualities, but also heterosexual males who share tastes and interests that might be said to deviate from the norm. And to demonstrate this, I'd like to look at the contents of the legislation and the acts that they ban. So first, we have the licensing restrictions. The BBFC guidelines provide a list of content that cannot receive licensing for online video on-demand programs, and they're presented on the slide. They include portrayal of sexual activity which involves real or apparent lack of consent, including any form of physical restraint which prevents participants from indicating a withdrawal of consent, infliction of pain or acts which may cause lasting physical harm, whether real or simulated, penetration by any object associated with violence or likely to cause physical harm, sexual threats, humiliation or abuse, and to note strong physical or verbal abuse, even if consensual, is unlikely to be acceptable. So in practice, writers seem to be in agreement that these guidelines mean that the following graphic portrayals of those activities are banned. I'll just leave them on a screen for a moment and spare me having to read them all out. Just to note as well, the three at the second bottom are considered to be life-threatening acts, which is interesting. So, next we have Section 63 of the Criminal Justice and Immigration Act, which makes it a criminal offence to, and I emphasise, possess pornographic images that contain certain acts. And those are an act threatening a person's life, an act that results or is likely to result in serious injury to what might be considered sexual areas of the body. And Section 37 of the Criminal Justice and Courts Act 2015 amended this section to add in images of rape and assault by penetration. And now, these acts perhaps sound like good candidates at first glance for banned material, but what do they include concretely? Well, first it's important to note that the depicted acts can be consensual or simulated, and therefore they can include role-playing and acted-out scenarios. And secondly, there is much vagueness about what counts as a life-threatening act, as well as what will be deemed an act likely to result in serious injury. And those lines are particularly important within the BDSM community, a definition of which I've left on the slide for you to read if you need. A lot of the materials I've just mentioned have a common theme running through them. That is, they involve sexual content that focuses on or would appeal more to a sexually non-mainstream audience. Perhaps most obviously, face-sitting and female ejaculation are overtly feminine experiences of sexuality. And it's curious that the male equivalents that are practically the staples of pornography do not seem to make this ban list in the same manner. Other acts are common within the queer community, something that was highlighted by the defence counsel in Aaron Walsh. In that case, a gay man was brought to criminal trial for possessing imagery of fisting, and the CPS, the fact that the CPS brought charges for materials displaying these kinds of acts arguably displays a lack of awareness of the world about sexuality outside heteronormative bounds. And I would contend that is quite concerning. If we look to the acts of physical restraint, humiliation, verbal and physical abuse, and bear in mind that all of these can be consensual and or simulated, these sound precisely like the kinds of activities that would typically be found within BDSM communities. Now, on the one hand, heterosexual males can have sexual tastes which align with those activities, and indeed in judgments such as Pay and the United Kingdom that was the case. Although Pay didn't involve the legislation I'm looking at today, it perhaps indicates part of a wider story where there's a lack of comprehension and therefore suspicion around those who enjoy these activities, and a resultant lack of sympathy for their sexual privacy. Just to clarify, in Pay the claimant was fired from his job for engaging in fetish clubs outside his working hours, and the courts at every level did not find that dismissal had been unlawful. Also of particular note is that there are strong links and overlaps between the BDSM and queer community. Additionally, both statistics in porn website traffic and sexual research studies appear to show that women tend to have a preference for more extreme forms of pornography than men do, and that trend also plays out in rape fantasy. And I just want to make clear that does nothing to support rape myths or the perpetuation of rape culture, but what it does do is show that sexual fantasies are complicated, nuanced, and very difficult to interpret. One factor of interpretation should be emphasised, however, and that's the vital line between fantasy and reality when it comes to sexual thought. And that can be illustrated by Hopkins's roller coaster analogy. People enjoy roller coasters because they provide a safe environment in which one can experience a situation of simulated danger and the thrill that that brings with it. The fantasy-reality divide, however, remains firm. Excitement would immediately turn to fear if the roller coaster riders began to believe that they were actually plummeting to their deaths. And that explanation seems obvious because riding roller coasters is a well-known experience for many of us. But that's not necessarily the case with sexual fantasies, which by their nature are highly private and individualized. And that's all the more so where they deviate from mainstream portrayals of sexual fantasy. There are two further points to note on interpreting sexual fantasies. First, a significant portion of those fantasies are sexually submissive, yet that hardly seems to be the kind of thought that the legislation appears to target, especially through threat of criminal sanction. Secondly, in rape and submissive fantasies, the very elements which make those acts deplorable are absent. In the fantasy, the supposed victim is in charge and exercises their agency in order to bring about pleasure. Their own pleasure, I might add. The objectionable elements of dehumanization, of the perpetrator elevating their interests above the victim, therefore fall away. The second point is that a collective of sexual abuse support centres have stated that many of their potential clients turn to those kinds of materials as a way of rationalising their trauma rather than seeking help. And while that might not be a constructive form of recovery, the imposition of criminal sanctions upon the very people who the legislation is supposed to protect just seems barbaric. There seems to persist, however, in people's minds, a barrier between female victims who need to be protected and bad people who possess these kinds of materials, but I've sought to show that that's simply and clearly not the case. Instead, the kinds of acts under discussion seem to have a more typical audience of women, those within the queer community, those of submissive fantasies, even sexual assault survivors, and those who in general have sexual tastes which deviate from the norm, but which nevertheless still have a healthy grasp on the divide between fantasy and reality. But does this matter? We can countenance that pornography is a bit low value anyway, so where's the harm in restricting it? Well, it matters obviously if people risk going to jail for looking at the things that turn them on. And it matters particularly if that group seems to be more likely to be a sexual minority. Further, it matters because this must be placed within historical context, as the first quote, also displayed at the beginning of my slides, shows. The thesis that I've been arguing for today is part of a much longer trend in the relationship between sexuality and the law, and the minorities who get caught up in that. To demonstrate the point, I need hardly highlight the laws used to target homosexuality, and women's voices on sexual matters, meanwhile, have been systemically silenced or overlooked throughout history. The very fact that prosecutions of homosexuality focus on male relations serves to illustrate the point. And the demonisation of those who are otherwise deemed to be experimental may be seen as largely steeped in traditional conservative views of the purpose and role of sex. It also matters because privacy, sexuality, and combined sexual privacy are vital aspects of identity and self-fulfillment for many people, and exploring or using sexual material for those purposes is simply an integral part of that process for many. Yet, as the second quote on the slide shows, criminal possession offences, such as those in section 63, risk tearing apart the core of sexual privacy through intrusive and degrading criminal investigation and trial. And the chilling effect that this may have upon people's ability to explore sexual fantasy cannot be ignored either. Finally, licensing restrictions play a role in perpetuating the narrative of valid types of sexuality. And the more that alternative voices are silenced, underrepresented and judged obscene, the more alienated and reviled those kinds of acts may become. And it would seem reasonable to argue, as well as being supported by the fate of Aaron Walsh, or the fact that it was even brought to court, I should say, the more risk there will be of non-mainstream sexual material being misunderstood and criminally prosecuted as extreme. Finally, of course, greater surveillance and investigatory powers provide the ready means to those ends. Where now, as the workshop title asks? Well, my PhD seeks to show that Strasbourg's doctrine on sexual privacy can extend protection to these kinds of materials, particularly in terms of criminal possession offences. The thesis that I've explored today, namely that these regulations have a disproportionate effect upon non-mainstream and often already quite vulnerable groups of individuals, provides key added urgency to recognising this kind of protection. The negative impacts upon those who do not fit into the sexually normative mould are steeped in misinformation and misinterpretation, and I would argue that it's high time they be left in the past. Thank you for your attention, and I'm happy to take any questions.